would ask you sworn.
Certainly. You, sir, solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. First of all, I want to thank everyone for their time. I know there's a lot of nights, a lot of time that the ZBA and the county board are spending coming to these hearings. So this is an important issue, and we truly appreciate your time. Usually I do not do an opening. In fact, this probably is the first opening I've ever done in a wind farm case. However, the things I've heard and said and read outside of this hearing have, regarding the law, absolutely require that I set a few things straight. I've been a municipal lawyer for 35 plus years, and I've been doing these kind of hearings in the renewable field for the past 10 plus years. My first one was 2015 here in Livingston County. Unfortunately, I am hearing certain board members are saying in public, on the radio, via email to the public and other board members, that they have no choice but to vote for this project if the project meets the standards set forth in the statute. 2, every vote against the wind farm under the statute has been overturned in court. 3, Livingston County will be sued for damages, personally and as a county. 4, the state will sue us if we do not approve this. All 4 of those statements are absolutely wrong. Can't even be close to true. These are either lies told to you or just plain mistakes by people who do not practice this type of municipal law. I would suggest that next time someone tells you that all these cases are getting overturned, ask to see the decision. There is not one decision, published or otherwise, in the state of Illinois that has overturned a wind farm denial, a solar farm denial. Hasn't happened. I keep hearing it, but there is no case. Some cases have settled, don't get me wrong, and this is not Prairie, this is not the Heritage Farm or Prairie Heritage, whatever it was called. This is completely different. I don't know where those statements are coming from, that every case has been overturned, or that you have no choice as a board. But whoever's telling you that doesn't understand or is not telling you the truth. No such decisions exist on any of these issues. We'll talk about each of them specifically in a minute. But they're nothing more than bald-faced threats without any support in the law or in fact. Let's go backward on these issues a little bit. 1, Livingston County and individual board members will be sued for damages. I've heard that a number of times if they deny this. Every board member who votes on this issue, as well as the county, has tort immunity. The Tort Immunity Act.
Mr. Haynes, I've been letting some of this go, but this is opening statement, not argument, and he's not making legal arguments.
I think I have the right in opening statement to set forth what the law is so that the board understands what the law is going forward.
He's not stating the law, he's arguing the law.
All right. Mr. Luke Haynes, where you get into, where you come close to the line between argument or an opening statement and testimony, then you may be subject to cross-examination.
That's actually why I asked to be sworn in.
So,
Well, is he testifying or is he making opening statement? Because we agree that he can waive his opening statement and make an opening statement. But to combine opening statement and testimony, I don't know that that is appropriate, number one. Number two, if he's representing witnesses, then he should not be also testifying in the same proceeding. Because as obviously under the ethical rules, he can't be both an attorney representing clients and a testifying witness in the same proceeding.
That's not the case in these cases. People testify all the time as lawyers because in zoning cases throughout the state, on a regular basis.
I'm going to allow Mr. Luke Hands to testify. I'm considering this more that he is a witness rather than an opening statement, because he's already come to the line of opening statement and heading across it into testimony. So there will be an opportunity for cross-examination of him with respect to his statement, with respect to the issue of whether he can serve as a witness and serve as an attorney for a group of objectors. I'm going to allow it because I have seen it on numerous occasions where attorneys have been sworn to testify when they have a client sitting next to them in a zoning hearing. I've seen it on a number of occasions. So I'm going to allow it, but I'm also going to allow you, Mr. Uphoff, the opportunity to cross-examine him, as well as members of the board and members of the public who are in favor or neutral on this particular issue. So, Mr. Luke Hands, with that, you may go ahead, but consider yourself a witness.
Fair enough. As I said, every board member who votes on this, as well as the county, has tort immunity under the Illinois Tort Immunity Act. It's clear. Not a doubt. So for you to be threatened, or for anyone to say you're going to be sued for damages, absolutely wrong. Not even close. Some of you were around for the proposed energy wind farm here, the Pleasant Ridge case. You may remember I was the lawyer for the objectors, and we filed a motion for summary judgment that won that case on the appeal in court. Invenergy is the 800-pound gorilla in this business. Anybody who watched that hearing knows that was a scorched earth application. There were 36
Gaines,
out here.
I'm going to object to the relevance that he's testifying. This isn't relevant to this proceeding.
It's not.
Well, it's about to be, so if I could just keep going.
All right, if it's about to be, I'll allow you.
They, even Invenergy, was not crazy enough to file an action seeking damages from the county or the individual board members. Why not? Because it would have been sanctionable.
Now he's testifying to what was in the minds of Invenergy when they were handling their litigation.
You know what? You can cross-examine me about it, whatever you want to do.
It's still irrelevant. I don't have to cross-examine. It shouldn't be.
Can I finish this opening statement? Or
It's not an opening statement. It's testimony. I'm objecting to your testimony. I have a right to object.
And the objection is sustained. I'm going to ask you to, if you want to make one more comment on the Invenergy case, but let's talk about this case. That's what's relevant to this proceeding.
believe me, if Invenergy thought they could have sued for damages, they would have. I heard this quote theory about getting sued for damages in every county I've worked in, which is many, and no one, not one time, has the county or the individual board members been sued for damages. Not once. I've been involved in 100 zoning hearings at least outside of this. Not one time was anybody sued for damages, even when there was a lawsuit. Monetary damages are not available. Not even close. If you don't believe me, ask someone to show you a case. Any case in the state of Illinois where without fraud, there was a determination that a zoning case, the people who made the decision on a zoning case, or the county, were liable for monetary damages. Doesn't exist. Next. Every vote against a wind farm under the statute has been overturned in court. Again, not true. Just wrong and a lie. Some cases have settled, no doubt about it. There are no published decisions on this since the Pritzker House Bill. No cases have been litigated to the conclusion that said a governmental body has no choice but to approve if you meet the state standards. At least 2 cases are currently being litigated on that issue. There has been no resolution of those cases, but those cases are being, at least one of them is briefed on a very narrow issue of is there any discretion in do LaSalle factors or the special use factors apply? In fact, all the briefs say it's the novel issue that has not, this is an issue that has not been decided by the courts. Next, you have no choice but to vote for this project if the project meets the minimum standards set forth in the statute. Again, just plain wrong. Wind companies, their lawyers keep saying it enough, they hope to believe it. They hope everybody believes it. Kind of companies, wind companies I know on everything actually. I used to date a girl who would try and say she was manifesting something by speaking it into existence. That's exactly what the wind companies have been doing on this issue for the last 2 years. If the legislature actually wanted to say that the county had no choice, all they had to do was no longer allow it to be a conditional use. They could have said, take it away from conditional uses, make it a permitted use if you make these standards.
Objection. He's not testifying his argument. This is a closing argument.
And we can say that for closing argument. Mr. Luke Hans, give testimony rather than argument.
Well, I think I have the right to say what the standards are or not that this board should be looking at when they review the testimony.
He's not stating the standards. He's talking about what happens in Springfield and what people are thinking when they're passing legislation and what county board members should have going through their minds. These are all arguments. He's entitled to make argument at the end. He asked for an opening statement. He asked for testimony. In neither opening statement nor testimony can you make argument.
The objection
is some of it go, but it needs to stop.
The objection is sustained. Let's give testimony and not speculate on what Springfield is thinking.
Okay, well, let's talk about the law. Springfield did not say it was permitted use. The General Assembly did not say it was permitted use. House Bill 4412 doesn't say it was permitted use. It says it's conditional use. With conditional uses come LaSalle factors. Come the standards that you have in your ordinance. Okay? That's very important to remember. They're set forth in section 56-629 of your zoning ordinance. You don't have to believe me. You have to listen to Mr. Uphoff the first night. What did he say when we objected to the testimony regarding real estate taxes?
Objection that he's commenting on other testimony. Witnesses are not allowed to comment on prior witnesses' testimony.
Let's stick to testimony, not argument, please.
I am trying to lay out the standards of the law for this board while they listen to what is going on. Let me finish, please, Mr. Uphoff, once. I have the right to tell them what the law is on this issue before they start.
He's not stating what the law is. He's trying to regurgitate arguments that I made first night.
I think that the Zoning Board of Appeals is fully aware of section 56-629, factors for consideration, those 7 factors that are enumerated in that section, known as the LaSalle factors. The board knows what they are.
I guess the question is, does the board know they apply? That's what we've been hearing from Mr. Uphoff. They don't apply. He said it in a motion. They told the public, the county board has told people it doesn't apply. If this ZBA is going to say yes, section 56, if the hearing officer is going to say 56-629 applies, I can move on.
It does apply. It's the law. It is the Livingston County ordinance passed by the county board, and after the House bill in 2023 was approved, the Livingston County board, in my understanding, codified this in their code of ordinances, and 629 is the law, and it applies.
Okay, thank you. When House Bill 4412 was enacted, this county hired Andy Kite to assist your ZBA in drafting new standards. Kite is a bona fide municipal zoning law. He does this every day. Kite told you ZBA the factors apply, and then what did he say?
I object. This is not relevant to the application. Now he's talking about what occurred at the text amendment hearing. You just stated the ordinance is the law. Now he wants to go back and talk about the creation of the law. Number 1, that's argument. Number 2, is not relevant to the proceedings here.
If I could finish my sentence, you would know that that's not what I'm doing.
Finish your sentence, and then I'll rule.
Okay. What Mr. Kite said, and it's the law, is that the two most important factors are the first one and second one of section 56-639. Property values,
Now
and
he's
health, safety, and welfare.
objection. Now he's arguing which factors are most important. That's argument. It's clearly argument.
It is argument, and I'm going to sustain the objection. And what Mr. Kite told this board, told the county board, it doesn't matter because the law is the law. 629 and those 7 factors are what this board will consider and what this board will apply in making its recommendation and what will then be decided by the full Livingston County Board when it's time for a vote. So let's talk about the application. Let's talk about what the relevant factors as you see them, please.
So let's talk about the relevant factors. As the two most important ones are public health, safety, and welfare, and property values. Most zoning cases are determined on those two issues. As to both of the standards, we disagree with the wind company's experts. I won't talk about what testimony was given because I would agree, because the out of order, that should be in my closing. But you will have the right and duty to take those standards, the credibility of the witnesses, and your own common sense to make your own determination. This is still your decision. That has not been taken away from you by House Bill 4412. And if you have the LaSalle factors, or the 56-629 factors, and they don't meet them, you have the absolute right to deny that. Absolute right. If you believe that the application is not compliant with the LaSalle factors or section 56-629, you have the right, not only the right, but the obligation to vote no to this application. I've also heard, as I said earlier, the state of Illinois will sue us. It's not what the state does. Again, there is no case where the state sues a county for having a zoning ordinance that is not in compliance. It's not what they do. Even if it wasn't in compliance, which it is, that's not what they do. You can't find, no one can cite a case to that. That comes up in the litigation or appeals after hearings. The state doesn't go do that. It hasn't done it once. Besides that, in this case, you also have a variation. That is an even higher standard than a special use. We'll talk about that standard more as we get there, but that's a heavy burden to show that they show practical difficulty or particular hardship. Even if the applicant was to try and state some form of hardship, you have broad discretion to grant or deny a variation. Nothing in House Bill 4412 even comes close to that. So I'd ask that you listen to the evidence, not come into this hearing with a preformed idea of what you can and cannot approve. The evidence will show that they haven't met these burdens. And when that's done, I'll come back to you at the closing and ask for a vote to deny this application. Thank you.
All right, thank you, Mr. Lutkehans. All right, questions for Mr. Lutkehans, first from members of the Zoning Board of Appeals. Gentlemen, any questions for this witness? Very good. County Board, questions? Other members of units of local government, including school districts? Licensed attorneys? Cross-examination, Mr. Uphoff.
No questions.
All right, very good, thank you. Questions from interested parties, members of the public who are either in support of the application or neutral on the application? Thank you. Livingston County staff and consultants, Ms. Miller?
No questions.
Mr. Delewski?
No questions.
Mr. Redlin-Schaefer?
No questions.
All right. Then, final questions from the Zoning Board of Appeals members, but seeing none. Thank you, Mr. Lutkehans. You may step down. Call your next witness.